I don't see the participant number jumping up, so I think we're going to get started. All of these slides will be provided to participants. You'll get an email after the presentation, so you'll have all these slides for your use and note taking and everything along those lines. But for now, let me turn it over to Jessica.
Good afternoon. Thank you, Tawny. And we want to thank our partners in this, Verrill Law and the Healthcare Purchaser Alliance. A benefit of membership to provide this very useful information as we navigate these very unusual times. So thank you, Tawny and Trevor, for participating in this effort with us. Trevor?
Thank you, Jessica. Yeah, also thank you guys so much for including us on this. I really appreciate it. For those that aren't familiar with the Healthcare Purchaser Alliance, we're a nonprofit organization that works with employers and public trust to try to advance value in our healthcare system. I apologize to everybody, but I actually am going to have to drop off the webinar a little bit early to deal with some family issues that have come up this week. But I did want to note that our organization has spent a lot of time over the last few weeks talking with testing and compliance vendors. And I'll leave my information in the chat box if folks are looking for solutions to address the testing mandate or are just looking to bulk order tests. I can help direct you to some high quality vendors that we think would be a good option for folks. But again, thank you, Tawny, Verrill, and the Manufacturers Association for including us in this. We really appreciate it. We're happy to be part of this conversation. Tawny,
Thank you, Trevor.
Thank you.
Thank you. Thank you, Jessica. For those of you who don't know me, my name is Tawny Alvarez. I am a partner in Verrill's Labor and Employment Practice Group. I am housed in our Portland office, but my practice takes me throughout New England. Information about me isn't what you're here for, so let's jump right into it and get a sense as to where we're at. As I set forth at the beginning statements, if you missed that, please use the chat function if you have questions. Ask those questions during the course of the presentation. I think it's always helpful for participants in the audience to have an understanding as to what we're going to be talking about. We have four main things that we're going to talk about today. One, understanding the legal challenges. We are getting lots of questions regarding what does it mean when the Fifth Circuit issued the stay? What's going on in the Sixth Circuit? How does all of this work? So we're going to have a foundational discussion about where we're at as it relates to the legal challenges. We're then going to talk about what the rule provides, and simultaneously we're going to bust some misconceptions. So there's a lot of misconceptions out there about what this provides. It doesn't help that they're calling it an OSHA vaccine mandate when it really doesn't mandate that the vaccine be taken by employees or forced. There are options as it relates to the OSHA mandate. Finally, we're going to talk about best practices for responding to the rule. While we currently have a stay, there are still steps that you and your organization should be taking for as the legal challenges kind of play out and progress, and in order to maintain a healthy and safe work environment for your employees. So with that, let's jump right into understanding the Fifth Circuit decision. So many of you know, in early November, lawsuits, and I say lawsuits because there were multiple lawsuits were filed in the Fifth Circuit alleging that the OSHA vaccine mandate and this ETS, emergency temporary standard, was improper, that OSHA didn't have the authority to issue the ETS for a whole number of reasons. And it's important to understand why was it filed in the Fifth Circuit? Why was it filed in Louisiana? We have a number of different pieces of case law, both regarding challenges to OSHA mandates and also challenges regarding emergency temporary standards. The standards that are used in different jurisdictions vary. In the Fifth Circuit, it has one of the strictest standards, and that's one of the reasons why the plaintiffs filed initially in the Fifth Circuit. However, we had so many other cases that were being filed all over the country. And as a result, it ends up that we're going to have multi-district litigation that's all subsumed and that's going to be in the Sixth Circuit. But let's talk about what happened in the Fifth Circuit before we get to the Sixth Circuit. So Plaintiffs filed a lawsuit in the Fifth Circuit requesting that the court stay or enjoin OSHA from instituting its policy. They argued that the ETS was improper, and they asked the court to issue an order saying they don't have the authority to do so and stay implementation of the mandate. The court granted that motion to stay, and it found that the ETS was outside the scope of OSHA's authority for a number of reasons. One, they found that the mandate is over-inclusive, right? One of the reasons why one would issue an ETS is because there is direct threat to everyone who is covered by the ETS. Here, it's very clear that not every workplace has had COVID cases. So it's hard to argue that every single workplace that's covered by the ETS needs it because we all haven't had COVID cases in our work environment. Next, the argument was made, and the Fifth Circuit agreed, that the mandate was under-inclusive. Why was it only applicable to employers who had 100 or more employees? That didn't make sense. You have a similar COVID issue regarding unvaccinated employees for employers who have less than 100 employees. Thus, the mandate's under-inclusive. Next, they talk about the fact that right now, OSHA is attempting to use the ETS as a stopgap measure. Very specifically, we have notes in the course of the ETS itself that says, we understand that different industries are going to have different issues, whether it is a meat packing company where people are standing right next to each other all the time, or it's an accounting firm. They have different needs. The industry requirements are going to be different. But the thing is the current ETS doesn't have differences for industries. If you have 100 or more employees, the same obligations are going to be applied. But under regulations concerning when OSHA can issue an ETS, it can't be used as a stopgap measure. Next, the Fifth Circuit said also the ETS flunks a cost benefit analysis. It's estimated that the ETS is going to cost $3 billion in compliance costs. And in analyzing kind of why the ETS was put in effect, OSHA indicated that it's really only to protect unvaccinated employees. So it's not to protect the public as a whole. It's not to protect vaccinated employees. We are only looking in this ETS to protect unvaccinated employees. That was the goal or the direct threat that OSHA said it was responding to. So we have these 4 reasons why the Fifth Circuit says, nope, ETS is improper. OSHA went further than they were supposed to, but they also throw in these 2 other concerns, and these are the constitutional concerns. Under judicial review and rules regarding judicial opinions, a court is never to reach or decide a constitutional issue if there is another way to decide the case. So if you can decide the matter without reaching a constitutional question, that's the way the court should reach it. Here, however, the Fifth Circuit said, yes, the OSHA standard's improper, a stay is going to be issued for all these reasons, but also here's some constitutional concerns, and they set forth 2 of them. One was the Commerce Clause, that potentially the ETS violates the Commerce Clause because a person's choice to remain unvaccinated and forego regular testing, it's a non-economic activity. So it's something that the federal government wouldn't have control over because we're not talking about interstate commerce. This is a personal choice, and it's non-economic activity. So Commerce Clause would limit OSHA's ability to regulate. The next aspect that they bring up is the police power argument. Throughout the course of the pandemic, any case that has gone up to the Supreme Court regarding different states and governor's orders and mandates concerning restrictions as to gatherings or mask mandates or similar things, the court has indicated that states have very broad police power. And one of those things is to provide for compulsory vaccination. So police power is held with the state. But here, there's a strong argument to be made that OSHA is attempting to exercise that police power, which is improper because that's designated to the state. As a result of all these findings, the Fifth Circuit then grants the stay pending review. It also ordered that OSHA take no steps to implement or enforce the mandate until further court order. Now, what becomes really difficult is that 3 days after the court issues this order, we have news and the media blowing up saying OSHA is indicating that it won't implement the ETS. Yes, OSHA is taking that step. They put on their website, we're not taking further actions to implement it, but they're also saying they still believe that it's within their power and the ETS is not void and that the stay should be lifted. But under the Fifth Circuit's ruling, they have to take that action. They have to indicate that they're not going to implement it or enforce it until the stay is lifted. That brings us to the Sixth Circuit. So after the Fifth Circuit issued its stay, we then had the multi-district litigation. A multi-circuit lottery occurred, and the Sixth Circuit was ultimately chosen randomly as the place that is going to house this litigation. So right now, and if we go to the next slide, we'll see the breakdown of each of the different circuits. The red columns indicate the number of judges who have been appointed by a conservative or Republican president, and the blue columns indicate the number of judges within the circuit that have been appointed by a Democrat president. So you see the makeup, and you'll see that the Sixth Circuit is made up pretty similar to the Fifth Circuit. A lot of people believe that this is extremely important to the current analysis because they believe there's a higher likelihood that Republican appointed judges will find that OSHA overreached and the ETS is outside the scope of what they can mandate or legislate. Legislate's not the right word because there was no legislation here. We had simply administrative power taking over. But that Republicans are going to be more like, Republican appointed judges will be more likely to find that OSHA is overreaching. Right now, we don't know what judges will hear this case. So you'll see that there's 28 judges, and that includes our senior judges. A panel of 3 judges would then be appointed, and it would be at random to hear the case. There is, however, argument as to whether or not this matter should be heard what's called en banc. And en banc means every member who's not in senior status would sit and hear argument on it. And all the judges would get to come together to decide the issue, and you'd need a majority of the judges in order to have a determination. Right now, we have the United States has filed a motion to remove the stay, and there is a briefing schedule that's been set up in which, as of Tuesday, so 2 days ago, parties could have joined the motion to lift the stay. The plaintiffs have until Tuesday, December 7th, to respond to the motion to lift the stay, and then the government can file its reply motion by December 10th. You're thinking to yourself, Tawny, why are you telling me this? I don't care. You have to care because that means nothing happens until December 10th. So if you thought that, you know, on the 4th or the 5th, when this is supposed to take effect, or a large number of the ETS provisions take effect, and we're going to talk about that later, it won't, because we still have a briefing schedule that goes until the 10th. So we'll still have a stay as of the 10th. We'll then have either oral argument or a decision after the 10th. The last thing from a court perspective that it's important to understand is this argument concerning the Supreme Court. Once the Sixth Circuit rules, are we in a position in which we will have an answer, or do we need to wait for the Supreme Court to weigh in? In order for the Supreme Court to weigh in, there either has to be disagreement between the circuits on an issue, or there has to be a constitutional question. As I mentioned earlier, there's a lot of ways where you don't get to the constitutional question. So the Sixth Circuit, if they get to a constitutional question, it's because they've found all the other aspects of the ETS are legitimate and within OSHA's power. So that's the only way they get to a constitutional question. Next, if they were to find that the Fifth Circuit was correct, there wouldn't be a change in the circuits. Both the circuits would agree on the issue, so you wouldn't have a split, which then decreases the likelihood that the Supreme Court would take it. Those of you who are in today's presentation are super lucky, as opposed to those who attended the presentation 2 weeks ago, because you get more information, because there's been this evolution, not just of the data and information concerning where we're at and how it's being viewed, but you also, I have more time to dig into some of the legal history concerning different circuits. And one of the other ways that the Supreme Court potentially could take on this case is if the standard of review that the Sixth Circuit uses to review the ETS differs from some of the other circuits. So we have past cases in the DC Circuit and the Second Circuit that use different standards when they're reviewing an ETS. Depending on what standard the Sixth Circuit uses to review the ETS, an argument could be made that there would then be a split in the circuit between the Second Circuit and the Sixth, or the DC Circuit and the Sixth, regarding how an ETS is reviewed, just the standard itself, which also could potentially put it before the Supreme Court. Those, however, would be the only three ways we would see it. The last aspect that I want to talk about that relates to jurisdictional questions and who's in charge of what and how we move forward before we get into the meat of the ETS itself is state laws. So let's jump to the next slide. Specifically within the ETS, and anyone who's attended any of the presentations that I've given before know that I always talk about, yeah, we're talking about state law, but you have to consider federal law, or we're talking about federal law, but state law still applies. Same issue here. We're talking about federal law, but state law still plays a role, except that the ETS attempted to decrease the amount of, or the strength of that role. Specifically, the ETS notes that it preempts state laws if there is a state law that limits an employer requiring a vaccination. So in different states, Texas, Florida, that have legislation that say an employer cannot mandate the vaccine, ETS and OSHA is saying, nope, this ETS preempts those state laws. Those governor's orders are secondary to the ETS. You need to follow the ETS. It only, however, relates specifically to COVID vaccinations, but other state laws that are more protective of employees continue to be applicable. And this is going to be relevant as we move forward in the discussion about who pays for testing, because there's going to be medical examination and testing state laws that are going to come into effect when we're talking about the content of the ETS. So I've now spent 17 minutes talking about all different aspects of the ETS, but we haven't even started talking about the ETS. So let's jump into it. The first question I'm hearing from employers is, what workforces are covered? Does this even apply to me? So who is covered? If you have 100 employees or more, you are covered by this. All levels, all locations, part-time, full-time, remote, in-person. This isn't like the FMLA where you have to be within 75 miles and you have to have 50 people working there. No, 100 employees, it doesn't matter where they work. It doesn't matter if they only work 1 hour a week, they count as an employee. We do, however, exclude independent contractors and staffing agency workers. So those staffing agency workers are going to be counted by the staffing agency that employs them. Independent contractors are going to be counted towards the company that those independent contractors work for, but they're not going to be included in your company's 100 employer count in determining whether or not you're covered under the ETS. The other thing that comes into play here is the question that a lot of people had before OSHA issued the ETS itself, which is, should I have terminated employees prior to the ETS coming out so that I was under 100 employees? Now, most federal mandates do a 6-month look back, and they say, if within the last 6 months you had 100 or more employees, this rule or mandate is applicable. Here, however, what they did was they said, as of November 5th, anytime into the future, if you have 100 or more employees, this ETS is applicable to you. So as a hypothetical scenario, November 5th, you only have 93 employees, but on December 1st, you have 104 employees, okay? ETS starts on December 4th. It's now applicable to you, okay? But as of December 20th, you terminate 5 employees and you're down to 99 employees. The ETS, however, is still going to apply for the length of the ETS. In most situations, an ETS is only applicable for 6 months, which means we're looking at this ETS until the beginning of May. There's not an end date, but the whole purpose of an emergency temporary standard is a 6-month period of time is what's at issue. So past May, OSHA is going to have a hard time attempting to enforce this. So if you have 100 or more employees between November 5th and May 5th, the ETS is going to be applicable. Unionized workforces are covered by the ETS standard. OSHA is very specific and says it doesn't matter if you're unionized or not unionized, this standard is applicable. This becomes another one of those really interesting situations where we have administrative agencies who are all jockeying for position, because 5 days after this ETS comes out, the NLRB, which you all know to be the agency that oversees union activities in the National Labor Relations Act, comes out with this memo that says the only things that are relevant to the union are what is mandated. But if there's anything in which there is a question as to whether or not the employer must do something, that is subject to bargaining. And it's important for employers to understand that not every single aspect of the ETS itself can simply be pushed through, because if there is a choice for an employer to do one thing or another thing, it's likely subject to bargaining. Next, people who or companies who it doesn't apply to. If your workforce is covered by the Safer Federal Workforce Task Force, COVID, workplace safety, guidance for federal contractors and subcontractors, you are excluded. So if you're a federal contractor, you're excluded because you're covered by or you're subject to Safer Federal Workforce Task Force. However, you also are likely aware that earlier this week, a stay was put in effect for the whole United States. First, it was only for 10 states, and then another order came down which stayed the program for all states, in which currently the Safer Federal Workforce Task Force is not being implemented at this time. And then employers covered by the healthcare ETS are also excluded. That healthcare ETS does remain in effect. There hasn't been any exclusions. However, we also know that the Medicaid and Medicare, the CMS mandate also comes into effect. CMS mandate has been stayed, but again, most CMS individuals likely fell within this healthcare ETS, and the healthcare ETS still remains in good standing and hasn't been stayed. So that's who's covered by the ETS. Let's get into, however, what's required under the ETS. So we've talked about all the court decisions. We've talked about who it's covered. Let's talk about what it requires. One, an employer has to have a policy on vaccinations, okay? They aren't going to submit this policy to OSHA. OSHA may come and audit them and ask to see their policy itself, but this is going to be an internal document that they're going to share with their employees, and that's going to be a framework as to how they're dealing with COVID within the organization. In addition, the policy on vaccination does not include any language concerning natural immunity, because OSHA under the ETS does not identify natural immunity as being legitimate as a form of protection. So while the ETS is focusing on unvaccinated individuals, there is science out there that shows that individuals who have had COVID have similar immunity to COVID again. Again, the data is all over the place. There's some that say that they're heightened immunity. There's some that say that it's not as strong of immunity as if you get the vaccine. But having COVID previously is not going to constitute vaccination under the terms of the ETS. Your policy on vaccinations likewise then would not be able to take that into account in creating the policy. What needs to be included within the policy itself? We need to have definition of what fully vaccinated is, which is having your 2 shots. There's no mention of the boosters at this point in time. There could be an evolution of this ETS, but definitely not while the stay is in effect. We need to have language concerning requirements for COVID vaccinations. If somebody is unvaccinated, what that's going to look like. So if they will be the requirement that they're going to have to test weekly, requirements for masks, you're going to have applicable exclusions. So individuals who are indicating that they can't be vaccinated as a result of medical necessity requiring a delay in the vaccine, medical accommodations as a result of a disability, sincerely held religious beliefs, your ability or the organization and how they're going to respond to those requests needs to be included in the policy. We need to have information concerning paid time away from work and sick leave for vaccination purposes. We need to have information concerning obligations of employees if they have a positive COVID-19 test, and also how we will remove those individuals from the workplace. We also need to identify all the information that we're going to be providing to employees. Now, I just ran through a ton of things really fast. The good news is now we're going to run through it in a slower fashion with me providing more details about each aspect of this policy. The first thing we need to do is we need to determine the vaccination status of our employees. Here, there are specific documents that can be accepted. I know a lot of organizations have already done some type of vaccine kind of discussion or dialogue with employees where they may have asked people, are you vaccinated? Aren't you vaccinated? Can you attest to that? Here, however, you need documentation. There's only one way that you can have an attestation that will meet the criteria to determine vaccination status. And that individual is going to have to very specifically attest to the fact that they have attempted to get proof of their vaccination from a multitude of different sources, but have been unable to for one reason or another. So these are the very specific documents that can be accepted. You have confidentiality obligations with regards to maintaining these records. So my recommendation is you take the copy of the vaccination card or other document, you place it in the employee's confidential medical file. The next thing you have to do, though, is you can't just keep it in the file. OSHA is also requiring you to create vaccination record or a roster that can easily be handed over if you're audited, and to determine status if you do have a positive case. That document, that roster, however, also is going to need to be treated as a confidential document, with really your HR team limiting access only to those with the need to know, most likely those only within the HR team. So that is how we're going to determine vaccination status. OSHA then says, well, we also understand that there's a bunch of people who are unvaccinated. That's what the whole ETS is about. So next, we want to support employee vaccination. So that's the next element. And in support for employee vaccination, employers, if we jump to that next slide, employers must provide up to 4 hours of paid time off at the employee's regular rate of pay. You cannot require employees to use personal or sick leave in order to be vaccinated. So if you have unvaccinated employees, your policy has to provide, you'll pay them 4 hours to go and get vaccinated. You can require employees who have to miss work because of side effects that they experience as a result of the vaccine. You can require that they use sick leave, but you can't require that they use vacation leave. So if you as an employer have sick leave and vacation leave and the employee has used up all their sick leave, you can't require them to use vacation leave. You're going to have to provide them with paid leave to recover from the symptoms that are associated with the vaccination. If you have 2 chunks of leave that are vacation and sick leave, the sick leave can be used. If you have 1 chunk of leave, PTO, that PTO can be used for the side effects from the vaccine. You can't require employees to use advanced sick leave. So you can't say, hey, next month you'll have your extra day of sick leave, take that now and you just won't get it next month. No, you're going to be required to pay them for the time away from work. You can set a cap on the amount of paid sick leave to recover from side effects, but it must be reasonable. In regular government fashion, they don't define what reasonable is, but in the dialogue, you can read in the 400 pages, I think 2 days is an appropriate period of time that OSHA would find to be appropriate to pay for that leave for symptoms or time needed to recover from side effects. Let's jump and talk about our unvaccinated employees. So if they don't take that time off to get vaccinated, they choose to remain unvaccinated, they're going to be required to be tested for COVID once every 7 days. Now, this does not apply to employees who are 100% purely remote. If, however, you have a hybrid model where individuals are remote part of the week and in the office another part of the week, they have to be tested prior to coming into the office. So 7 days prior to entry, they would have to be tested before coming into the office. So either the week before, if they're a weekly employee and they're coming in every single day of the week, or if they're not coming into the office every day, within 7 days of coming into the office, they need to be tested. Additionally, unvaccinated employees are going to have to wear masks. Isolation and face covering, however, is very specifically noted as being insufficient. So testing plus face covering is what would be required. You can't just isolate and use face covering. This is where there's some really interesting questions because we see more and more arguments being made concerning religious freedoms and refusal to test for COVID generally, and how that would interrelate to this fact that isolation and face covering is insufficient, which would likely lead to work from home being the only possible alternative, which isn't going to be sufficient in a lot of situations. Employers can use pool testing, so they can take a group of employees who are unvaccinated, pool test. If it's negative, great. If it's positive, everyone's going to have to test individually. We have an employee who has tested positive in the past 90 days, then we suspend testing for the next 90 days. Again, this is directly contrary to this. Isolation and face covering is insufficient. So we have the second group of people who are saying, okay, you don't have to test. If you've had it before, if your religion says that you can't, those would be 2 ways in which we maybe are saying isolation and face covering is sufficient. We have to maintain records of each and every test result in the employee medical record. So for our employees who are vaccinated, we're taking a copy of their vaccination card and putting it in their record. For our unvaccinated employees, every week, the documentation is going to need to be placed into their employee file indicating that it was negative or positive or whatever the results were. Now, who pays? Under the ETS says that employees are going to be required to pay for testing. Those of you who weren't working in the 12 to 15 minutes prior to jumping on this call likely saw that Biden had a press conference right before this presentation, and he is now indicating that health insurers are going to be required to provide the COVID tests to plan participants free. How that will happen, I don't know, and it's still too new for me to get a complete understanding as to what that's going to look like. But so the ETS says employee, Biden's now saying healthcare provider. Maine law, however, says the employer in some format is going to have to pay for it. So the employee definitely isn't paying for it. Under Maine law, you can't require the employee to pay for a medical exam, and a COVID-19 test would constitute a medical exam. So that's what we know and is important about testing. But big question. I feel like I keep saying something and then I'm like, but what does that mean? What test constitutes a COVID-19 test? 3 things have to be met, 3 standards must be met. And the most important aspect is, see this 3? Not both self-administered and self-read unless observed by the employer and authorized telehealth proctor. That means that for those of you who have been able to find the COVID tests at Walgreens or at a pharmacy and who are bringing them home and who are testing and are currently accepting those for employees, that would be insufficient because the employee is testing themselves and they're reading the result. You'd have to have a telehealth proctor, which you would get through your health insurance provider or through another employee assistance program, or an employer who is watching and observing the reading. Now, one way to do this is it doesn't say it has to be in person. It just says it has to be observed by the employer. For your employees who maybe work remotely in some format or fashion, you could have the individual swab, wait the 15 minutes, show it to the employer before they come into work. Otherwise, you're either going to need to have them go to a location, you're going to have to get them a telehealth proctor, or you're going to have them come to work 15 minutes beforehand and do the test. The problem with all of this is that's all compensable time. So you need to pay them for this time. A wage and hour claim could be made if you're not paying people for the time associated with the testing. So it's not just paying for the test itself, it's also the time that's associated with taking the test and waiting for the result. Okay. So we've talked about testing. We've talked about support for vaccinations. Let's talk about what happens if, unfortunately, an employee does get COVID. So notification of positive tests and removal. Next slide. So an employee who tests positive must promptly notify the employer. So your policy is going to need to provide, if you test positive, you need to notify the employer as soon as possible, no less than 24 hours or the beginning of your next shift, right? I say as soon as practicable, not just before the start of the shift, but also, I mean, if someone tests positive on Friday night, you don't want to wait until Monday morning to hear about this. You're asking them to notify you as soon as possible. Employees who do test positive have to be removed from the workplace. They could telework or work remotely if that is a possibility for the organization. However, they can't be in the physical work environment. The time away from work is going to be unpaid under the ETS. The employer could choose to pay the employee, could choose to use vacation or sick leave, but the ETS doesn't require payment. If there's false positives, this is a time where you're going to want to talk to counsel about best practices, because there's different tests that are going to need to be used. If an individual first tests positive and then they do a second test that's showing that they're negative, the type of test that is being used is going to be important for determining which test is going to win out as to whether or not you're positive or negative. This is the interesting part of it. And this is where I think a lot of people are struggling with the ETS and the protection. Close contact. So there's no requirements that unvaccinated employees be removed. So if you have 2 unvaccinated employees within the work environment, they've been within 6 feet of each other for more than 15 minutes, right? So we have that close contact standard still that we're getting from the CDC. When Bob tests positive, we don't have to let Sally, who's working right next to Bob all day long, we don't have to say, okay, you're out. You have close contact, you have to quarantine for 10 days. There's no requirement for that. There's no requirement that we do any form of contact tracing. So all these things that previously CDC was saying we need to do, CDC is still saying we need to do it, but OSHA isn't adopting and including that in the ETS. There's also no requirement that we maintain records under the ETS of that positive test that somebody has tested positive for COVID. But recall that just because the ETS says that you don't have to keep the documents doesn't mean that other standards aren't in effect. When someone tests positive for COVID, a very strong argument can be made that they're a disabled person for that period of time, and the ADA is going to apply, and you're going to want to collect information. If you are an employer with 50 or more employees, or in Maine, 15 or more employees, the Family Medical Leave Act or the Maine Family Medical Leave Act is going to be applicable, and you're going to need to keep records under those statutes. So just because the ETS isn't requiring the documents be maintained, you still have to maintain it under these other standards. Okay, so removal, if you test positive, for unvaccinated individuals, they have to have face coverings. What is a face covering? So it has to completely cover the nose and mouth. It has to be made with 2 or more layers of breathable fabric that's tightly woven. It has to be secured to the head with ties, ear loops, or elastic bands that go behind the head. If a gaiter is worn, it has to have 2 layers of fabric folded to make 2 layers. It has to fit snugly over the nose, mouth, and chin with no large gaps on the outside of the face. It has to be a solid piece of material without slits, exhalation valves, visible holes, punctures, and other openings. All of that information should be included in your policy about what a face mask is. There are exceptions to face coverings requirements for unvaccinated individuals. Those include if the individual is alone with floor to ceiling walls and the door is closed, they can take their mask off. If the employee is eating or drinking, they can remove the mask. If they need to show their full face for identification purposes, the mask can be removed. If the individual has to use a respirator or face mask, then no mask would be worn. Or if the face covering is infeasible or creates a greater hazard to the employee, then they don't need to wear the mask. Additionally, face coverings also need to be worn if the unvaccinated individual is in a vehicle with other work individuals. So if people are carpooling, these mandates would apply during the carpooling to work or from work if there are multiple employees in a vehicle, or if people are traveling between locations as it relates to work. This creates some really interesting additional wage and hour questions because you're attempting to mandate or create rules at a time in which they're not being paid. But that's, you all know that I could talk about this for multiple hours, and everyone trying to keep me to 1 hour has been tough. So we're gonna jump to the next topic, but recall you've got this whole chat button if you want to ask questions. If you want to stay on later, you can ask questions. Notice to employees. You have to provide your employees with your COVID policy. You have to describe to them the process that the organization is going to take to determine vaccination status. So if you're going to use a survey monkey, if you're going to go individually to different people, but what process will take to determine the vaccination status. Leave and pay policy entitlements if someone wants to obtain a vaccination, what their rights and obligations are if they have side effects following the vaccination. Procedure as to what they're supposed to do if they have a positive COVID-19 test or diagnosed with COVID-19 by a healthcare provider. The procedure for requesting records. This is really, we're going to talk about this, but this is one that really irks me. You're going to tell it irks me when we start talking about it. Key things to know about COVID-19 vaccinations, anti-retaliation rights that an employee is entitled to, criminal penalties for false vaccination cards. And for unvaccinated employees, you need to provide information on COVID-19 testing and face coverings. This document, key things to know about COVID-19 vaccines, that's a CDC document. So you can get that on the CDC website. Many of the other things you either need to create or provided specifically from OSHA. The next obligation under the ETS is that the employer must report fatalities and hospitalizations. So in order to be a reportable incident, the COVID fatality or hospitalization has to be work related. Okay. So just because an employee gets COVID-19 doesn't mean you have to report it to OSHA if they're hospitalized or they die, unless it's tied to the work. It doesn't apply to employees who are working remotely. The question of whether it's work related is going to be a fact specific determination. Do you have a clump of people who have gotten COVID? Are you in a healthcare-esque environment? Do you have other reason to believe that the individual got COVID from an outside source? All of those factors are going to come into play in determining whether or not it's a reportable incident. In order to report it, it's going to be an instantaneous type report. We're not waiting until the end of the year or the end of the quarter. You can either telephone the OSHA area office, you can call OSHA toll free, or you can submit an electronic submission. When you call or set up your email, you're going to need to provide the name of your company, the deceased or hospitalized employee's name, time and location of exposure, description of the incident surrounding exposure, and the name and contact information of you or the employer's designated contact person. So that is our reporting of fatalities and hospitalizations. So we have a question. Can I assume employees who are on the floor with hot chemicals wearing a mask would constitute a larger hazard than without the mask? So that, that question, going back to who needs to wear a mask and who doesn't, you're going to have to look at the different elements. So the temperature that's in the space, the chemicals that are being used, if the mask itself could cause them to have more difficulty breathing. If there's another type of mask that they can be using that would provide similar protections, all of those elements would come into play in the very fact-specific determination as to whether or not masks need to be worn by unvaccinated individuals in that circumstance. Last element of the ETS is record availability, and this is the aspect that I struggle with and that I say to employers, it's the last thing that we're going to think about, okay? Employees are entitled to see their own COVID-19 vaccine documents and look at the text, should say test results by the end of the next business day. So employees would come to you and they'd say, I want to see my COVID file. And the only thing that's in their COVID file is all the things that they've provided to you that they arguably already have a copy of. Their vaccination card, it's either a vaccination card or it's all their negative screens, right? You have to respond and give them copies of those documents by the end of the next business day. Additionally, if you receive an authorization or a consent form from a third party, but that's signed by the employee, that individual would be entitled to have the records by the end of the next business day after the request. So the individual is entitled to all of their own documents, which they arguably already should have, but you have this very limited period of time in order to respond to it. Next, employees are entitled to two numbers. They're entitled to the total number of employees in the workplace and the number of individuals who are vaccinated. These two numbers aren't going to be set out forth or in a format where you can determine this department or that department. It's just going to be two numbers. We have 240 employees and 200 employees are vaccinated. That's all they would be entitled to. The ETS and OSHA believes that this is important from a labor relations standpoint, and the employees are entitled to have an understanding of the statuses of the other individuals who they are working closely with, even though they wouldn't be able to identify the people who are at issue or who occupy those numbers. let's jump to the effective date. So we've just run through all the things that the ETS provides, and you're thinking to yourself, okay, Tawny, you started with this statement that everything's been stayed, okay? Now you've told us about who it applies to, who the employers are, what the ETS standards are, when does it become applicable? So if there was not a stay in effect, these elements, all with the X on the left-hand side, would all go into effect on December 6th. But recall that earlier in the presentation, I told you that there's no way that they're going to go into effect on December 6th because we have a briefing schedule that goes till December 10th. So there's no way that a stay will be lifted before December 10th. There is a possibility that on December 11th, the stay is lifted and all of these elements immediately go into effect. The likelihood of that is slim, is very slim. But it also means that you need to be mindful that these are the first priorities that you should be considering. We're going to talk about best practices and what you should be doing now despite the stay. And then on January 4th of next year, that's when the weekly testing requirement goes into effect. So January 4th is when testing would go into effect if the stay is lifted. If the stay is lifted and if ultimately the ETS is found to be appropriate, there is a chance that the stay is lifted and the litigation proceeds and we don't have a decision as to the appropriateness of the ETS as of January 4th. If that's the case, employers would be required to be in compliance with the ETS at that time because there's no stay. It would be enforceable until we have a ruling that OSHA has overstepped or the ETS is unenforceable. So considering all these things that I've just told you, what are the best practices? What should you be considering and keeping at top of mind right now? One, the rule has not been overturned, okay? So we, yes, have a stay, but we don't have anyone saying this is never happening, this is never going to happen. We still have a long way before we are at a place where we're able to say that. Second, and this is what I find most concerning and why I think it's important that we're spending so much time talking about this. OSHA's general duty clause remains in effect. Ooh. So, can people hear me now? Okay, so it remains in effect. What does that mean? We know that the general duty clause is very broad. Says an employer is required to provide a safe and healthy work environment for an employee. Now, depending on the industry, depending on the work environment, that's going to be different, okay? In the scenario that was set up in the chat, we know that that work environment is going to be different from a retail location. It's going to be different from a restaurant, right? The hazards at different work locations are different. But for unvaccinated employees, we now have this guidance as to what ETS says is most important to provide a safe and healthy work environment to unvaccinated employees, specifically that being the masking. Okay, it being a policy that requires that an individual who's tested positive be immediately taken out of work and restricted from returning. So we have these provisions. I would recommend, and my recommendation to clients and friends has been create a policy, okay? It's set forth in the ETS, but it's also best practices for your organization generally, okay? You don't have to mandate the vaccine, but figure out how you're going to get the information from employees beforehand, right? So if you don't want to get the information yet because you want to hang your hat on the fact that the stay is not going to be lifted and a court's going to find that this is improper, that's no problem, but have your plan in place, both for how you're going to get the information and then also what your practice is. So a lot of people, once we got to, January of 2021, people's COVID policies, they either stopped implementing them, they stopped updating it. they stepped back from having these policies and started dealing with things on a case-by-case basis. I implore you to recreate a COVID policy to provide protections, because you have employees who likely think that this ETS is extremely important and that the mandate should be in effect. And it's those individuals who are going to go to OSHA and make allegations that you're not providing a safe and healthy work environment. And my goal would be to protect you from any claims such as that, that an employee could make, that you're failing to provide a safe and healthy work environment under the general duties clause, and that you see a retaliation claim or otherwise an OSHA audit, when, you know, that's the last thing that any of us need right now, is dealing with an OSHA audit on top of all the things that you're all doing kind of within the community more generally.
Tawny, if 2 employees tested positive, could those employees then say, I caught it in the workplace and file for workers' comp?
They could, but it would be, that's a hard, we haven't seen that argument win yet. So we haven't seen the COVID workers' comp argument win, specifically in non-healthcare environments, a stronger argument in a healthcare environment. Those individuals are going to be entitled to leave under the ADA or Maine earned paid time or FMLA or Maine FMLA. Unlikely that workers' comp would apply, but an argument can be made that with the 2 cases, if the ETS was in effect, that you have reporting obligations. But good question. Any other questions? We have a small group, so you're welcome to unmute yourself. You can use the chat function. I know it's the end of the day, so I appreciate all of your attention. If not, or if you think of something later, you can always email me. I'll turn it over to Jessica for closing remarks, but thank you all for your attention and best wishes.
Oh, thank you. Thank you for this wonderful presentation, Tawny. Of course, we will be monitoring and, if as warranted, provide future opportunities to put together a forum like this again, as it seems like it's ever evolving.
Sure. Jessica, is MAME going to put together some sort of a structure, if you will, based off of this presentation? I know things are changing constantly, but if I heard Tawny right, a close contact doesn't need to be sent home. And we just sent our production manager home for 10 days a couple weeks ago as the guidance from our HR consultant.
Yeah, so CDC does still recommend that action. That becomes a really interesting part of all of this. Is CDC guidance still says that people should be sent home if that happens. ETS requirement doesn't require it, but that's what the CDC is recommending. So the employer has this obligation as well under the general duties clause to follow that CDC guidance. So even though they're not following that ETS, CDC guidance would be what employers are recommended to follow right now. And this is another moment where confusion is created.
Not trying to be the thorn all the time, but from a legal standpoint, what side are you taking, the CDC or what we're required? Because again, I'm not jumping through hoops to do more than what's required. Right?
Yeah, I recommend CDC guidance, just because I'm not an because I'm not a medical provider, epidemiologist. So the concern being that if you don't send other people home for close contacts and you have a full outbreak, what that looks like, both from a PR standpoint for your organization, as well as if you were to experience a death or some other significant issue, the exposure or liability that you could have for not following the CDC guidance. Now, the argument would be the ETS doesn't apply to me, but you have this other guidance that says this is best practices for a business organization. So it depends, unfortunately, is that horrible legal answer, but the CDC is who I rely upon for this information, just because I'm not a healthcare provider. If there's the ability to find other information concerning other countries that are providing different recommendations. Sometimes I've seen companies that will rely upon that, but that would be my guidance. Follow-up question about documentation of test results. I don't see a problem with accepting at-home tests, especially for organizations who are in northern and central Maine. It's my understanding that COVID tests are still, you're multiple days out in booking. So if you have employees who are able to do at-home tests and can show you the result, I don't have a problem with them returning to work with a negative screen, or after 10 days of not experiencing symptoms, or whatever the CDC's current guidance is on that. Amy, I'm sorry, I'm not seeing if you want to unmute, but I am not seeing your question or comment, so I apologize.
She's still here?
Yeah, Amy Volk. Okay, Amy, you
Can you hear me?
Now I can hear you. Yep.
Okay, yeah, for some reason, I moved offices and my video doesn't work, and I didn't think the mic would probably work either. So my question is it illegal for an employer to have, rather than doing the 10-day quarantine, if they were identified outside of work as a close contact and they're completely symptom-free, is it illegal to allow them to work if they're unvaccinated, as long as they pass a test before their shifts?
No. And are you talking about every shift? I mean, you could have it be every shift. An
Yeah.
argument's been made. Yeah. An argument's been made that every shift is really the best practice, which then goes against the 7-day. But no, I see very little risk if someone's asymptomatic and they're being
Right.
tested that regularly, that they
Yep.
would be able to come into work, even with the CDC's guidance, because you're taking a step that is I think even more protective of the health and safety of the other employees. And recall that the ETS is based off of protecting unvaccinated employees.
Mhm.
With this employee being unvaccinated, you're testing them daily and they're symptom free. So I don't see that as a problem at all, Amy, and I don't see it as high risk. And Erin, that goes to your question as well too, about following the CDC guidance. You know, what Amy has just set forth wouldn't follow what the CDC guidance is, but it would provide more protections for the unvaccinated and the vaccinated individuals in your workforce without losing their ability to provide services or the wages during that period of time for that family.
Kind of sounds like what the president talked about children testing to stay in school, that they
Right.
may be tested daily if they've been exposed so that they can remain in school. So it seems like it's kind of along that same vein.
Yeah, so I don't see risk on that.
Yeah, that's really helpful to know, because, you know, we have had, like Erin was saying, we've had some people that, you know, I mean, they've been out of work for 10 days without income. And, you know, I mean, these are working class people that can ill afford to do
Yep.
that. So, and we can ill afford to have them staying out at this point in time. So to me, that is a higher standard, and I'm happy to hear that you feel that that would not be illegal in any way.
Yeah, no, I don't have a problem with that. Accessing the tools and equipment needed for that, having the tests, making sure that everything stays confidential. Those would be the important aspects to it, but it
Mhm.
keeps people working. And I
Right.
think that's definitely one of the goals. And it's people are working safely because
Mhm.
you know they're asymptomatic, you're testing daily. So we're kind of back to where we were at the start of the pandemic, but you're still keeping people safe, and that's most important.
Right.
And Trevor provided his email in the chat earlier, that he has access to vetted out sources of large quantities of testing supplies. And
Oh, where is
we'll get,
that?
Health Purchasers Alliance. I can get you Trevor's email. We'll also include it in our policy alert on Tuesday. Trevor and I will connect. And he has some information that we will share along with our membership.
Oh, good, because we've been just having people pick them up at Walgreens or Walmart or wherever, and then, you know, that they limit. So that's good to know.
Hey, Tawny, this is Holly. Realistically, once we get through the courts and if it goes to the Supreme Court or not, how quickly, if they ruled that it was in effect, how quickly would businesses have in order to pull the policies and all of these other deliverables that they need to do? Will they give them enough time to be able to do it?
My fear is that, considering how strongly OSHA has indicated that they believe the policy is legitimate and within their authority, that they won't extend the timeframes, and that they'll expect people to be in compliance very quickly. So I'd say within a week of whenever we have that, if not already in compliance within a week. And because they're going to say, we've maintained this position the whole time, there's no difference. We've given you the notice to be working on this. They're going to pretend that they, you know, turn a blind eye to that $3 billion price tag. The concern being, right, is that even as employers are taking steps to come into compliance, I'm less concerned with an audit. I'm less concerned with OSHA coming in and finding out you're not completely in compliance. I'm more concerned about an individual employee bringing a lawsuit against you from a safety standpoint, or becoming a whistleblower and making allegations and putting themselves in a protected class in that format.
So are you recommending that your clients start putting the policies in place and all of these things so that they're ready to go?
Yeah, so
Just in case.
employers who have 200 or fewer employees, I'm recommending that they get the vaccine information from their employees. They have their roster ready and they have their policy ready to go. That's the only things that I'm recommending. If you have more than that, my recommendation is that you create your policy itself. You make sure your leadership team is all on board, whether or not we're just following the ETS, or are they considering a full mandate where everyone has to be vaccinated unless they are entitled to an exception. One of the big reasons to get that information is because your employees who are looking for a religious accommodation or a medical accommodation, that process is time consuming and it's not quick. A lot of times engaging counsel is important, especially with regards to the religious accommodation requests that we're seeing, but you're looking at 2 weeks, and for small HR departments, it's a heavy lift. So I've been recommending that at least the policy and figuring out what your workforce looks like is what's important right now.
Great, thank you.
Really, really good questions.
Excuse my ignorance on this, but who does authorize, I guess, a religious exemption? I said that to our HR and she, I don't say pushed me off, but didn't really give
No,
much
so
of an
that
answer there.
would be something that the team itself, so an employee would come, they'd request a religious accommodation based off of sincerely held religious belief. And then your HR team, your operations team would sit down and they'd say, okay, well, what's the accommodation that we can provide? And can we provide an accommodation? Is there a sincerely held religious belief that forces or plays a role in the employee's inability to follow a policy or a practice? In the past, we really have only seen requests for religious accommodation as it applies to working on the Sabbath or day of rest, so working hours, or sometimes one of the big cases was against Abercrombie and it was regarding a head covering and whether or not that violated a dress code or if it violates safety hazards. Here, when it's more of a vaccine policy or they're saying that their religion doesn't permit them to wear a mask, we have these larger public health discussions that come into it as to whether or not we can accommodate the requested accommodation. So it's just like a disability accommodation dialogue where we're going to go back and forth with the employee, operations, HR to see what accommodations we can provide.
Makes sense.
Thank you all. So we are 10 minutes early over. If you have questions that you realize you didn't ask, please, you see my email address, you know how to contact me. Thank you all for your attention. Have a wonderful evening and stay healthy.
Thank
too.
you.
See you in the morning, Tawny.
See you in the morning, Erin.
A long day. Have a good night.
Bye.